Good morning. Can everyone hear me?
Yes.
All right. Welcome to an oral argument session of the 5th District Court of Appeal. I'm Judge Eisnagel. I'm joined today by Judge Evander and Judge Harris. And here at the 9 o'clock session, we have case number 2659 McLean versus Orange County. And if the appellant would just let me know, counsel for appellant, if you just let me know how much time you'd like in rebuttal, I'll try to help you remember when we get there. And with that, counsel, you are free to proceed whenever you're ready.
Thank you. Good morning. I'm Heidi Parker and I represent the appellants. I'd like to reserve 5 minutes for rebuttal. May it please the court. There are 3 main points in this appeal that I'd like to present to you. First, the lower court wrongly applied Hollywood v. Perrin to the facts in this case. That case is at 292 Southern 3rd 808 4th DCA 2020. Second, the lower court erred when it denied the plaintiff's motion to compel arbitration. And third, the lower court erred when it dismissed the complaint in its entirety. Through briefing, the parties agree that de novo review applies in this case. I'd like to give you a brief overview of the facts because it's relevant to the legal issues.
I think we're pretty familiar with the facts. Let me ask you, on your first point, are you saying that the Perrin case was wrongly decided, or are you saying it was distinguishable?
Both.
That it was wrongly applied. Okay, go ahead.
Okay. So Perrin involved a grievance filed by an individual. That individual ultimately sought relief in the trial court to compel arbitration under 682.03 of the Florida Arbitration Code. The difference between Perrin and the case before you is that McLean's grievance was filed by the union. This is important because in Perrin, the collective bargaining agreement stated that only the union could process the grievance to arbitration. This is common in collective bargaining agreements that only the union can go to arbitration for the grievance. But in Perrin, he was asserting his rights as an individual without the union's involvement. And that's important because there was no agreement then in Perrin to arbitrate his individual claim.
Was that the basis of the Perrin court's? Was that the reasoning in the? I just don't recall that reasoning in the opinion.
Well, those were the facts, and so the case stands for the proposition that an individual cannot bring a complaint to compel arbitration in circuit court. And Perrin also stands for the proposition, well, Perrin was wrongly decided, I'm sorry, because, I'm sorry, I'm just kidding.
That's okay, counsel. Take your time.
I'm lost in my notes, I'm sorry.
I guess my question about Perrin is, I understand your argument, and it's a good point. You know, any holding is constrained by the facts of the case, right? That's well settled, so I understand that. But the Perrin court, as I recall the case, seemed to base its holding on the definition of an unfair labor practice. Right.
So the unfair labor practice alleged in that case was that the employer refused to meet on Perrin's grievance. That is clearly by the letter an unfair labor practice charge pursuant to the Public Employees Relations Act. In this case with McLean, he's alleging, and the union is alleging, that there was a breach of the collective bargaining agreement. So a breach of a collective bargaining agreement, the Florida court has said that that is not a ULP. Maxwell, 330 Southern 2nd, 177, the 4th DCA 1976, explicitly said that a breach of the CBA cannot be, is not a ULP. So Perrin presented a ULP, a straight ULP to the court, and the court said that it doesn't have jurisdiction to hear that PERC has exclusive jurisdiction over that claim. That part of the decision was wrong, legally wrong. An individual cannot bring a ULP to PERC on its refusal, on the employer's refusal to process a grievance. It's not a ULP. So that's how the parent court.
Why doesn't it fall under 447.5011A? Interfering with, restraining, or coercing public employees in the exercise of any rights guaranteed them under this part. And part 2 has a provision, I don't recall exactly which provision it is, but part 2 has a provision requiring a provision for arbitration, binding arbitration, right? So why isn't it fit under that?
And are you talking about Perrin or McLean's case?
No, either one. Well, when the county refuses to arbitrate, why is that not an unfair, or at least potentially an unfair labor practice under 1A?
It may be. It may be. But that's PERC's decision to determine whether something is an unfair labor practice charge. And if it is an unfair labor practice charge, the court has concurrent jurisdiction over the claim.
So this goes to your argument that we should be looking at Chapter 682, correct?
Yes.
You're not arguing that it's not an unfair labor practice. You're arguing that, well, whether it is or not, 682.03 nevertheless applies.
Yes, that's correct.
Okay. So why isn't 682.03 then just what appellee says it is, that it's a general provision, and Chapter 447 is the more specific?
So Chapter 447 requires that the parties have final and binding arbitration, but it doesn't give the union an avenue to enforce that section. The only statute that gives the union the ability to enforce 447 is to go under 682. And 682 does not exclude labor arbitrations from its section. In fact, it contains language that contemplates.
Why couldn't the union file an unfair labor practice claim under 447?
Arguably it could have, but it chose not to. And it chose to bring its claim as a breach of contract claim. And
right. That's the key question here, is whether or not that was an option.
So putting aside the statute of limitations argument that the appellee made, it could have been an option to do that. However, there were remedies requested by the court that PERC could not have awarded. And so the plaintiffs should not be denied a legal right or legal remedy just because PERC had jurisdiction over one part of the claim.
Your position then is it your position that any unfair labor practice can be challenged either under 447, or you can just skip 447 altogether and go straight to compel arbitration, or go straight to circuit court.
I'm not sure if any of the unfair labor practices can also be pursued in trial court. I haven't done that research to determine which issues are concurrent and which issues are exclusive to PERC. I think it may be the case that it depends on the issue. However, in this case, in McLean's case, there was concurrent jurisdiction over the claim, and there's a Florida case
specifically which claim? All of them?
The breach of contract claim, which I think is count 1 of the complaint.
Your brief on the breach of contract claim as to why that was an unfair, why that was or wasn't an unfair labor practice, or why there was jurisdiction for that claim in circuit court. As best I could tell, that was on page 40 of the initial brief. Was it argued? Was it laid out somewhere else other than page 40? And the reason I ask is because page 40 includes this, what appears to be this argument, but it's one sentence. And so it's just very difficult to understand what the argument is just based upon one sentence on page 40 there.
Yeah, there's another section that does address that, where
what argument are you making in this one sentence on page 40?
So that would add to the argument that a breach of the CBA is not a ULP. Just get to this. Oh, so it looks like it's relying on DeSoto. And it's a jurisdictional. So this part on 40 is just a jurisdictional statement that the circuit court has jurisdiction over breaches of contract claims. And that is supported by DeSoto and other cases.
Relying on DeSoto and Maxwell to say there's concurrent jurisdiction. Am I understanding you correctly?
I'm sorry, I couldn't hear you.
Relying on DeSoto and Maxwell to say that there's concurrent jurisdiction between the circuit court and PERC?
So DeSoto County School Board says the circuit courts and PERC have concurrent jurisdiction to construe collective bargaining agreements. And in a breach of contract claim, that's what the decider is tasked with.
Is that concurrent jurisdiction limited to determining whether the claim is arguably arbitrable?
That's not my understanding. That is arbitrable. It's a subject matter jurisdiction statement, as opposed to whether the issue is arbitrable. Arbitrability is commonly done by an arbitrator. And so you can review, in order to compel arbitration, the court can determine whether an issue is arbitrable based upon the contract and whether there's a violation of the contract and whether there's a grievance process that culminates in arbitration. So that is what makes the issue arbitrable to compel arbitration. And that
I don't know if the other panel members have other questions on these issues, but if you can, I'd like to hear some about the due process argument.
okay.
Move on to that.
Yeah, so when the parties initially, the defendants filed a motion to dismiss the complaint in its entirety based upon the exclusive jurisdiction of PERC. The court denied that motion correctly, stating that the court had subject matter jurisdiction. Then the union filed a motion to compel arbitration and stay the original action. The lower court denied the motion to compel arbitration, but then also dismissed the complaint in its entirety. And there was no grounds for dismissal of the entire complaint. The motion was scheduled on the motion to compel arbitration. So there was no notice to the plaintiffs that this issue was going to come up during the argument. The plaintiffs were not prepared to address that issue and were there only to argue on the motion to compel arbitration. So that is the due process violation, is the denial of the lack of notice to the plaintiffs of this becoming an issue again before the court, after the court already said that she had jurisdiction. The other due process violation is that the court dismissed the complaint in its entirety based on Perrin Perrin didn't address the issues on the dismissal of the breach of contract, the breach of the third-party beneficiary contract, and the equitable estoppel claims. There was no reason under Perrin to dismiss those claims. Those were separate claims. And so the plaintiffs are being denied the right to present these claims to the court. They're being denied access to courts.
Let me ask you this. So the Perrin case was brought to the court's attention after previously denying the motion to dismiss. First of all, is a trial judge permitted to revisit the case, particularly in light of being advised of a new decision from a higher court?
Yes. Yes.
You think the trial judge did not have the right to revisit its prior decision, or it could do so?
Yeah, I think the court could do so. However, it has to be noticed that that's what the court is going to do. There has to be some kind of.
Okay. Well, did the court give both sides an opportunity to respond in writing after the conclusion of the hearing?
Yes, I think so. I think they could have presented, the parties presented proposed orders in this case.
If both sides, but did they have an opportunity to present a memo as well?
How about a motion for a hearing?
I think in the proposed, yes. I think that in the proposed order, they could have argued the case in a memorandum, the plaintiffs.
Okay. Would that constitute due process? They would have had notice of the issue and an opportunity to be heard on the issue.
Yes, I understand your point. Yes.
Okay.
Counsel, you have 2 minutes left. Do you want to save it for rebuttal?
Yeah, let me just make sure. Yes, please. Thank you.
All right, counsel for the appellee, whenever you're ready, you can proceed.
Morning, Your Honors. My name is Mark Sugarman, and I represent the appellee, Orange County. And may it please the court, Ms. Parker. I'll start by addressing the court's questions about the procedural due process. And I'll first say we're here on de novo review. And so under NC versus Anderson, due process is satisfied through issuance of a written disposition subject to a subsequent challenge. And so the very fact that the court issued an order on a motion to dismiss and the union's up here on review on de novo review, they are now having an opportunity to present their arguments. Now, even at the trial court level, due process was also satisfied through notice and an opportunity to be heard. I'll address the court's, I think Judge Evander asked whether the parties were given the opportunity to file written submissions after the hearing, and they were. They filed proposed orders, and appellant actually also filed a notice of subsequent authority specifically addressing the jurisdictional issue. During the hearing, the judge repeatedly asked counsel for argument on why parent didn't apply and why the case should not be dismissed for lack of subject matter jurisdiction. So at the trial court level, both parties, including appellant, were on notice that the jurisdictional issue was being considered by the judge. They had an opportunity to argue that at the hearing. They had an opportunity to file a proposed order, and they did end up filing a notice of subsequent authority. And all of that culminated in the issuance of a written disposition by the judge, which is subject to a de novo appeal. Now, addressing...
Does the breach of contract claim fit into the definition of unfair labor practice under 447.501? And if so, which definition?
Yes, Your Honor. Let me start by saying this, that Amato versus City of Miami Beach, 208 Southern 3rd, 235 states that whether a claim is within PERC's exclusive jurisdiction depends on the nature and the substance of the claim, not on how the plaintiff labels the claim. And what I've heard from appellant and read from appellant in their briefs is that they could have filed an unfair labor practice, but they chose not to file an unfair labor practice, whether or not it was within the statute of limitations or not. They did not file an unfair labor practice over the refusal to bargain. And the way counsel described it in their briefs and here today is that they chose to file a breach of contract claim or relabel the refusal to bargain claim as a breach of contract.
What was the substance of the breach of contract? What did they allege in the breach of contract?
The breach of contract is that appellant McLean was denied a $1 pay increase in 1990.
It had nothing to do with arbitration. It was that he was denied part of his wages, correct?
Yes, he was denied part of his wages.
So as to the breach of...
I'm sorry, Your Honor.
I'm just trying to figure out under the breach of I assume that your position is that the breach of contract claim in substance is an unfair labor practice claim, correct?
The breach of contract claim is subject to arbitration under the collective bargaining agreement. And the county, that's the other part of the breach of contract claim. And I apologize for interrupting, but the other part of the breach of contract claim is that the county breached the contract by refusing to arbitrate the issue about the $1.
That seems like a separate issue, but the part of the breach of contract, that breach of contract claim that says, hey, look, I was owed this extra $1 per hour for all these years. Is that an unfair labor practice claim or not?
No, it is a breach of the collective bargaining agreement, which the parties have agreed by contract that the only venue to pursue that breach of contract claim is through contractual grievance and through arbitration. That is by contract, the parties have agreed to it. In fact, the parties are required by Section 447 to arbitrate breaches of the collective bargaining agreement. So that's why that breach of contract is not subject to a breach of contract claim.
Your point is it gets subsumed into the arbitration issue.
Yes, Your Honor.
Okay.
What about your argument? What about your argument that because the plaintiff had retired, he was no longer a part of the collective bargaining agreement? If that was the case, wouldn't his only action be to bring an individual action?
Well, his action is to file PERC, and PERC can resolve the standing issue. In fact, appellant stated that in when they were arguing earlier. She said that's PERC's decision whether or not something is an unfair labor practice charge.
Yeah, but under your argument, first of all, it wasn't a breach of contract with him individually. His argument was he was owed money based on the terms of the collective bargaining agreement. He could be a third-party beneficiary, but it wasn't a contract directly between him and the governmental entity, the city or the county.
Right. He is not a signatory to the agreement.
Right. So again, if the union can't argue for him, you're saying he can go directly to PERC anyway, even though he's no longer a member of that bargaining unit? I mean, I'm not sure I agree with you. It wasn't a that he couldn't proceed under the collective bargaining agreement just because he retired. But you made that argument, so I'm trying to figure out where that goes.
The reason I'm hesitating is because he could have for 26 years. This contract he was under this contract from 1991 through his retirement. And that's why I hesitated when I responded to you, because there was ample opportunity throughout his employment to file the breach of contract, which in this case, contractually, that's by filing a grievance.
But leaving aside the statute of limitations issue, if he was no longer part of the collective bargaining agreement, according to your argument, how would one proceed? At that point, he is no longer a party or third party beneficiary to the contract. The contract does not apply to him as a retiree anymore. So he can't go to either PERC or the circuit court? He could have gone to PERC, and then PERC has to resolve whether he has standing. I mean, he has a right to file an individual claim with PERC that the county has refused to arbitrate his grievance under this particular contract, but he didn't do that. And that kind of gets to the point that, appellants have argued that there was no avenue to enforce this and to get this issue, to get the remedy, to seek the remedy, but there was an avenue. When the county refused to arbitrate and said, we're not going to arbitrate your claim because you're a retiree, what PERC says is that's a refusal to bargain. We've cited two different cases at PERC that have held that the refusal to arbitrate a grievance is an unfair labor practice. City of Clearwater, 9F per 14278, and International Union of Police Associations versus Sheriff of Broward County, 46F per 157. And that was Mr. McLean's avenue. That was the union's avenue to go to PERC. And it sounds like appellants have essentially conceded that they could have gone to PERC. And if they could have gone to PERC, then that puts us directly under the Maxwell case. This court's decision in Browning versus Brody, 796 Southern 2nd 1191, and the Perrin case, that if something is arguably an unfair labor practice, and what appellants have stated in their briefs, in their filings with the lower court and with this court, and have stated in oral argument today, is that the refusal to arbitrate over that contract violation, over the failure to pay the $1 issue, or over the failure to provide arbitration to a retired employee, they've said that is an unfair labor practice. And so if it is an unfair labor practice, it clearly meets the arguable standard established in Maxwell, and it clearly should have gone to PERC. And
I understand. There's no doubt there's some cases out there that support your position. But if we just looked at the statute, is it 1A or 1F?
It's a refusal to bargain, 1A.
Well, 1A is interfering with, restraining, or coercing public employees in the exercise of any rights guaranteed under this part. Is that right? Okay.
Yes, Your Honor.
It wouldn't be refusing. It wouldn't be refusing to discuss grievances in good faith pursuant to the terms of the collective bargaining agreement.
You're right, Your Honor. It also falls under F.
Okay, so you say 1A and 1F.
Yeah, when unions or employees file unfair labor practice, actually, if you look at the form with PERC, and I don't have the record citation here, but I'm sure it's in the record, it's actually a pre-generated form, and 447-501A is on the pre-generated form. That's sort of the all-encompassing section of para that encompasses all unfair labor practices. And then generally a union or an employee will add another subsection after that and say, well, generally it violates 1A in this case, because 401 requires arbitration, 447, 401 requires arbitration. So by refusing to arbitrate a case, that restraint, if proven, obviously, it restrains employees in their rights to arbitration under 401. And then I just, it had a lapse, but 501 1F more specifically covers the refusal to discuss grievances in good faith.
I guess the CBA, it's not, when you first read that discuss grievances, it doesn't necessarily seem to encompass binding arbitration, but when you refer to the CBA, perhaps it is. Refusal to arbitrate would be refusing to discuss the grievance in good faith because the CBA requires arbitration.
Yes, Your Honor. In those cases that I mentioned earlier, City of Clearwater and IUPA versus Sheriff of Broward County. If you have any reservations about that, if you go read those cases, those discuss what sections the refusal to arbitrate violates and that it's an unfair labor practice. I'm not sure I've addressed the concurrent jurisdiction issue yet, but I know the panel had some questions about that. And I just want to talk about the DeSoto case because that seems to be where appellant is relying on that case. So what happened in that case is that there is a contract that provides there was a contract, a collective bargaining agreement that provided two different avenues for the union and union members to challenge things under the collective bargaining agreement. There was the statutory mandated arbitration process, and there was also a process referenced in the CBA where employees had to challenge discipline through what at the time was Chapter 200 something Florida statutes covering K-12 education. I think that's now encompassed in Section 101.2 or 101.3. But there was a dispute between the parties, and there was uncertainty between the parties on that case of whether or not employees challenging discipline needed to go through arbitration or the statutory process under Section 200. Or Chapter 200, pardon me. So the union filed an unfair labor practice saying that the employer refused to arbitrate. The employer's grounds for not arbitrating was, well, under our contract, you shouldn't go through the arbitration process. You need to go through this statute. And so the employer, while the ULP was pending, and that's crucial in this case, and that's why our case is distinguishable, because one of the reasons our case is distinguishable, because there's no ULP pending here, because as appellant has stated, they chose not to file one. But the employer, the appellee in that case, I guess they were the appellant in that case. They went to the circuit court and said, well, we need clarification among the parties of what process we need to follow. And that's what ended up going to the court, a declaratory judgment action to clarify the parties' rights under the contract. The court in DeSoto didn't consider the merits of the specific employee's claims. That's not appropriate for a declaratory judgment action. All a declaratory judgment action does is clarify the rights of the party. It doesn't deal with cases or controversies. And so
I'm curious, had the county not refused to engage in arbitration, would arbitration have proceeded under Chapter 682?
In our case, Your Honor, or in the DeSoto case?
No, in your case.
We would have proceeded to Section 82, and the rules of 682 are.
So in that situation, Chapter 682 would apply.
Certain provisions of 682 apply.
Okay.
The general arbitration rules, I mean, that's why parties do frequently file motions to vacate arbitration awards and labor issues in court, because PERC doesn't have jurisdiction.
In other words, it's not your position that 682 would never apply.
No,
your position is it doesn't apply here because the county refused to arbitrate.
Yes.
Right.
Precisely. And just because appellants have decided, well, we're not going to call it a refusal to arbitrate. We're just going to call it a breach of contract and estoppel and a third-party beneficiary. Somehow that relieves them of PERC's exclusive jurisdiction. The case law just doesn't support that. Perrin clearly doesn't support that. And that's the last thing I'll address in my couple minutes, unless your honors have any other questions, is that Perrin is absolutely not distinguishable at all. The facts in Perrin, I've said a law school professor couldn't come up with an exam hypothetical that was more close to the facts in our case. In both cases, they were covered by a CBA. In both cases, it was an individual employee saying, you didn't pay me right under the CBA. In both cases, they demanded arbitration under the CBA and the employer refused to arbitrate. And in both cases, the unions and the employees were claiming, well, it's not really a refusal to arbitrate. I'm really alleging a violation of the CBA, which is a breach of contract. In both cases, they filed a complaint seeking to compel arbitration. And in both cases, that motion was denied on a jurisdictional issue. In this case, the trial court clearly didn't err. It was required to follow Perrin because Perrin was binding. And the county's position is that the appellants haven't presented any argument whatsoever to give this court grounds to disagree with Perrin, because frankly, Perrin got it right. It applied Maxwell. It said that, look, we understand what you've labeled your claims at, but the real issue here before the court, the case in controversy, is not yet the pay issue, because that pay issue has to be arbitrated. The real issue here is that the employer is refusing to arbitrate that claim. And because that's the real issue, that's the real dispute underlying it, it is arguably an unfair labor practice, and it falls within the exclusive and preemptive jurisdiction of PERC. Thank you.
Okay, thank you, counsel. Counsel for appellant, looks like you have about 1:51, and you can proceed when you're ready with your rebuttal.
Thank you. So Chapter 682 applies because the county refused to arbitrate. When there's a refusal to arbitrate, then a party can seek to compel arbitration pursuant to a valid agreement to arbitrate. That's what this case is. The Perrin case was an individual who wasn't paid, but the union didn't file a grievance in that case. And that's the significant difference in this case. An individual may not bring a ULP on its own over the issues that we're talking about today. PERC does not have jurisdiction over individual claims. So to say that the McLean is the same as Perrin is just not, it's not factually accurate. Now this is not kind of a bait and switch thing or presenting something that is really something else. That the law says that the union has, that the court has concurrent jurisdiction with PERC to hear these issues. There's remedies allowed in the circuit court that PERC does not have access to, and a party has an opportunity to seek those remedies in circuit court, which is what the plaintiffs did here. In terms of the refusal to arbitrate, can I have just...
You can wrap up, counsel.
In terms of the refusal to arbitrate, that's an arbitrability issue, procedural arbitrability issue. That should go to the arbitrator, and the arbitrator decides whether McLean's retirement, whether he was able to bring his claim because he was an employee or not an employee during the breach, at the time the breach occurred. That is an argument to bring to arbitration. And I'll end there. Thank you.